special COVID-19 related VODcast, we will be talking about some very important questions that are arising in regards to employment law. I have spent many years working with startups and other companies to build human resources programs, so this topic is dear to my heart. Today, I'm joined by Katy Allen, who is an associate in the Labor, Employment, and Human Rights Group at Lawson Lundell. Hi, Katy.
Hi, thanks so much for having me.
Thanks for joining us today. Why don't you get us started by telling us a bit about your background and experience with Lawson Lundell?
Absolutely. So I am a senior associate at Lawson Lundell. We're a full-service regional firm, so we have an office Vancouver, Calgary, Kelowna, and Yellowknife. Our group specializes in labor and employment issues, so labor being the unionized workplaces, employment being everyone else. We do human rights, wrongful dismissal cases. We also assist drafting employment agreements, workplace policies, and that sort of thing. So we do a wide range of labor and employment services. And my background is that I did go to UBC Vancouver for undergrad. I have a Bachelor of Science, and I also went to UBC for my JD, my law degree. So I'm a UBCer through and through, and I'm happy to be able to talk to all of you about your COVID employment issues, because I know it's really difficult right now for employers.
Fantastic. Thanks so much. So Katy, there are new rules around taking unpaid job protected leave related to COVID-19. Can you speak a little bit about this and what that means?
Yes, so there are new leaves under our Employment Standards Act. So in BC, the Employment Standards Act has a couple of different job protected leaves. Most people are very familiar with, for instance, maternity leave or parental leave. And what those types of leaves are is that the employee is permitted to take an unpaid leave of absence in accordance with the rules under the Employment Standards Act for that leave. And during that time, if they're usually entitled to any benefits, like extended health and dental benefits, those benefits have to be continued during the leave. Although the employee can be required to pay their share of premiums if they normally pay something for those benefits. And when the person's leave is done, you do have to place them back into a substantially similar role. A lot of people think that you can't dismiss an employee who's on an employment standards leave. That's not technically the rule. The rule is that the fact that they took a protected leave can't be a factor in your decision to dismiss them. So for instance, right now, a lot of employers are, of course, making difficult decisions about laying off some of their workforce. And if that person who's on a leave is selected not in relation to any sort of protected ground, but just because they're in a group that's no longer able to be running right now, then you are permitted to dismiss them in accordance with the law and their employment contract, of course. So the new leave that was put into place this year in response to COVID is a COVID-19 leave. Employees are permitted to take a COVID leave on a couple of different grounds. One of them being if they actually are diagnosed with COVID, if they're in quarantine or self-isolation, for instance, if they've recently traveled back to Canada and they're caught under that federal order that requires them to self-isolate. If the employer has directed them not to work due to concern about their exposures to others, or a very common one we expect to see is if they have to provide care to an eligible person, and that's defined under the Act, but the most common example is a dependent child. Because, really the leave covers if you have to take care of a dependent child for any reason related to COVID. A common example is going to be because of school closures, daycare closures, etc. And it is also good to note that if an employee requests an employment standards COVID leave, you're not permitted to ask them for a doctor's note. I believe the purpose of that rule was, especially when these rules were, when the Employment Standards Act was amended, was the concern there was overwhelming the medical system, which is still a valid concern. So you're not permitted to ask for a doctor's note if the employee says, I need a COVID leave because I think I have COVID.
A hypothetical scenario: an employee cannot find childcare but is being told to go back to work. Does the employer have to accommodate in this situation?
Great question, and a really difficult one too. So if the employee is eligible for that employment standards COVID leave that we just talked about, that's kind of the easiest answer. If they meet the requirements under that leave, then they're entitled to a job protected unpaid leave of absence for as long as they require it. But if they don't meet that test, so if it's not because of a school closure, let's say the schools are all open in September, as normal, because right now schools are opening, but they're not opening full time. So I think an employee could still rely on that employment standards leave in certain circumstances. But in the future, if a parent is nervous about sending their child to daycare or school, but the daycare or school is open, they might not meet that employment standards test. And then the question is, what about human rights law? Does that protect them? So under the BC Human Rights Code, an employer or a person is not allowed to discriminate against an employee on the basis of family status, is what the protected grounds that this issue would raise. Family status is a very difficult test in British Columbia. The legal test historically has been a very high bar. It usually requires something, in typical times, it requires something more than I'm a parent, I have young children, I can't find daycare, I need you to accommodate this shift change for me, or I need a leave of absence, or whatever the employee's asking for. That typically won't rise to the level that will allow that employee to have protection under human rights law. It usually requires something a little bit more, like I'm a single mother, or I have a child who has a disability and they require constant care, some sort of special circumstance that rises to a level where the employer should make reasonable accommodations for that employee situation. In COVID times, of course, we don't have case law to guide us in this area, but most employers are, of course, being reasonable. Most employers want to ensure their employees are able to have work-life balance, meaning meet their obligations at home and continue to be an employee. So we're not seeing a lot of employers really, you only have to go down to the nitty-gritty of that legal test if it's an employee who you can't accommodate or that you don't want to accommodate for some reason. But most of the time, employers are just taking a reasonable approach. If they can allow the employee to have flex hours, if they can allow the employee to work from home or come to some arrangement, then it's usually, the most advisable course of action.
The situation has created a lot of nervousness around health and safety, especially as people are being asked to return to work. So could you address the number one question on everybody's minds? Do employees have to return to work if they're asked?
The short answer is yes. They do have to return to work if they're asked. Of course, there's always exceptions. So if an employee has been on a layoff or they've been working from home and now the employer wants them to physically come into the office, the only grounds on which an employee can refuse is the employment standards leave we talked about. So if someone's, let's say, been on a layoff, they've been home, their kids have been out of daycare, and now the employer is saying, we have work for you again, please come back, and the person says, oh, I can't send my kids to daycare, it's still closed, then they would go from being on a layoff to being on that employment standards leave. So that would be one reason why they could have a justifiable excuse for why they can't return to the office or their workplace. The other reason being human rights. So another protected ground under the Human Rights Code is disability. If someone is immunocompromised or has some sort of limitation due to a disability that means they can't safely come back to work, then the employer will have to accommodate them, and often an accommodation means an unpaid leave of absence. But something that's good to keep in mind is that if someone has been on layoff and you'd like to recall them now and that person says, I can't come back to work, I'm immunocompromised, my doctor says I should be completely self-isolated at home for the length of this pandemic, you can update their record of employment to switch them from being on a layoff to being on an approved leave of absence. So what that does is it stops the clock on the layoff, because in BC you can only have a temporary layoff in relation to COVID for up to 16 weeks in a 20-week consecutive period. So you want to make sure that you're diarizing when you did attempt to recall that employee and when you came to that accommodation arrangement that they're now going to be on a leave of absence. That's something to keep in mind. The other reason an employee can refuse to come back to work is on an occupational health and safety basis. So I know my colleague, Michelle Jones, did one of these VODcasts recently, and she addressed a lot of work safe issues, which is so important right now. She probably went over unsafe work refusals, so I would suggest looking at that if it's coming up for any anyone who's watching this. But if an employee does say, actually, I'm not returning to work because you haven't created a safe workspace for me, and I am, doing an unsafe work refusal, then you have to take steps to address that.
Excellent.
But other than those reasons, an employee who's recalled does have to come back to work.
Okay, that's really important.
Another thing I wanted to mention is that, I've heard chatter about employees who are on CERB maybe don't want to come back to work, especially if you're a part-time hourly employee. Maybe you're making more money on CERB, and who can really fault you for saying, I'd rather stay home safe and sound
I
than
see
come
this a
back
lot.
to work.
Yeah.
Right?
Yeah.
So, and that's, everyone can understand that, but at the same time, CERB is not meant to apply in that situation. And I think the federal government is starting to send messaging about that. So I know they just extended the eligibility period for CERB for another 8 weeks, which is great. But there has been some emphasis on this, if you need to be looking for work if you're on CERB. And from the employer's point of view, if you have an employee who's refusing to come back because they just want to receive CERB, you can amend their ROE to say, we attempted to recall them and they refused. And that's going to be a problem for the employee, because if the CRA does do an audit of their CERB benefits, they might be required to pay back some of their CERB benefits if they inappropriately rejected a recall to work.
I would imagine that would also negate any EI claim that they would put in after the fact.
Exactly. Yeah. So people who are switching from CERB to EI, that same rule would apply.
Right. Does an employee have to tell their employer if they've had COVID-19?
If an employee is in the workplace and they discover that they have COVID-19, there is a rule under the Workers' Compensation Act that the employee has to take reasonable steps to protect other workers in the workplace from unsafe working conditions. So again, although we don't have case law to guide us in this area, I think a reasonable interpretation of that would be, if you as a worker have been in the workplace during a time where you now know you had COVID, you likely should tell your employer that you have it. It's a bit of a gray area. If an employer came to me and said, we think this employee had COVID, but they didn't tell us, would I be telling that employer to discipline that employee? It would depend on any sort of applicable workplace policies or how they've handled other situations like that. You don't want to be singling people out. COVID is also likely a disability under the Human Rights Code, so you need to be careful about how you treat employees who you either perceive to have COVID or who might actually have it. But yes, an employee should report if they have been in the workplace and have potentially exposed others. That would be the best thing that they could do. And then the employer will be working with the public health office and potentially WorkSafe to ensure that any measures they put in place have worked to avoid the spread, and to see if there's anything else they should do in terms of notifying other employees.
So Katy, can an employee refuse to self-isolate?
If an employee has been traveling, there are laws right now about that you must quarantine if you're coming across the Canadian border, so they are required to self-isolate. But if it's a scenario where an employer has heard maybe secondhand information about so-and-so is not being safe, they're out with their friends, I don't feel comfortable with them being in the workplace, that's a much more difficult situation. You do have to be careful that you're not singling employees out and that you are respecting their privacy. So for instance, if someone is Facebook friends with them and they have a private account and that employee is showing you information from that private account, that might not be appropriate to look at or to take into account when you're making an employment decision. One solution to this is you can have a form that employees are required to fill out before they come back to the workplace, something like, have you been outside of the country in the last 14 days or the last month, whatever you want. Have you been to a different province? What province? Have you had any symptoms? You can ask them to take their temperature at home and record whether or not they have a fever as of that day. and have them sign that they declare that everything they're saying in there is true. That's something that we've been creating for clients as a way to, you can only ask the employee, and if they lie, they lie. And then if you discover that they've lied on that form, it's probably something that you could discipline them for. But that's really the best way that you can manage that situation. And when you're collecting that kind of information about an employee, it is personal information, and you have certain obligations under the Personal Information Protection Act in BC to safeguard that information as confidential. You should keep it in a locked cabinet. It should not be shared with others. You do have to make sure that you're respecting the employee's privacy. But in these particular unique facts, we are saying that in many cases, depending on your workplace, of course, depending on how much you can have employees isolated from each other or isolated from customers or whoever, then it is likely reasonable to ask them to make such a declaration to ensure the safety of your workers.
Katy, what advice do you have for companies who have held on for as long as they can, but as time wears on, are still considering temporarily laying off their employees during this crisis?
Yes, so temporary layoffs are a very tricky topic in employment law. Many employers have already put employees on a temporary layoff during this time. And the law says you don't have the right to temporarily lay off an employee. So maybe first I should get my vernacular clear. Often colloquially people say, I've been laid off. And what they really mean is I was dismissed without cause. But layoff sounds a bit nicer. And it usually means something like there was a shortage of work, there was a reorg or something like that. I lost my job through no fault of my own. In this context, when we're talking about layoffs, we're talking about a temporary layoff, where the employer says, I don't have work for you right now, but I'm going to keep you out on a recall list, and I'm going to call you back to work when I can. Under the BC Employment Standards Act, before COVID, you could only do a temporary layoff of up to 13 weeks in a 20-week consecutive period. In relation to COVID, it's now 16 weeks in a 20-week consecutive period. There's also case law that says, unless an employee has agreed to be temporarily laid off, you don't have the right to put them on temporary layoff. The reason for that is anytime an employer unilaterally substantially alters terms and conditions of employment, it can be a constructive dismissal. So the most fundamental term of employment is employer gives work to the employee, employee gets paid. If you're not giving work to an employee and you're not paying them, that's a constructive dismissal unless they've agreed to the temporary layoff, either because there's a temporary layoff provision in their employment agreement, in a collective agreement, or potentially you can argue they've implicitly agreed because it's custom in the industry. So, forestry industry, it's very common to have seasonal fluctuations and temporary layoffs. But unless one of those scenarios applies, technically when an employer temporarily lays off an employee, it can be a constructive dismissal. In COVID times, a lot of employers are doing it anyway, and a lot of employees are not claiming constructive dismissal because the reality is the employee wants to remain attached to the employer, and they can get CERB right now, or most employees can get CERB. So they would rather continue to be attached to their employer, have the right of recall, and collect CERB than say, actually, I've been constructively dismissed, you've terminated me, and my employment's over. So that's what a lot of employers have been doing. Because of the 16-week rule, that we're kind of, if your employees were laid off at the beginning of COVID, we're getting close to that time frame. If you are an employer who can recall your employees right now, either because you're starting to have work for them, or maybe you're eligible for the wage subsidy, the Canada Emergency Wage Subsidy, that if you're eligible subsidizes up to 75% up to a maximum salary. I think it's $847 a week for each of your employees. If you're able to get that wage subsidy, consider recalling your employees just to pay them that amount. Because if in the future things worsen again and you have to shut down again, or maybe the wage subsidy, right now the wage subsidy is going to end at the end of August, it would be good to not have to hit that 16-week time limit. So if they've been off work now for 15 weeks, recall them, pay them the wage subsidy, or provide them work, pay them if you can. And then in the future, if things worsen, you might have to put them on another temporary layoff. Of course, recognizing that unless they've agreed to it, it's always going to be a risk that you are effectively dismissing them. But it's kind of the best option for a lot of employers right now.
This has been really excellent advice, Katy. Do you have any last thoughts or advice that you want to give to our teams that we haven't covered yet?
I think last advice would be, this is a good opportunity to think about your workplace policies and your employment agreements, especially if you're a relatively new company. If you get a good employment agreement in place that has a temporary layoff provision that says the employer has the right to direct the employee to work remotely or from the office, that says if the employee is dismissed without cause, they're only going to receive employment standards minimums. Those sorts of provisions can be very helpful in these difficult times. I think that would be my advice. If you're able to look at those things right now, it's a good time to refresh and make sure that you have good paperwork in place.